what is the specific relation of the previous consideration in relation to two very important rights for the discussion we are having today, that is the right to benefit from scientific advancement and its application, and the right to health. And this has been developed by the committee in the general comment number 25, which is a very recent general comment. The committee has said that in principle, intellectual property can promote science and can promote access to science as it can promote innovation. However, the committee has stressed at least 3 factors that makes that intellectual property, on the contrary, can block scientific advancement and access to its benefits. And these are at least the three following. First, it can introduce distortions on scientific development, because if scientific research is conditioned by the gain of economic profits because of intellectual property, then very crucial researches are not carried on. That has to do, for instance, with all this issue of the so-called neglected diseases that are not investigated by pharmaceutical companies. Second, intellectual property can block access to information. Why? Because sometimes they are covered by industrial secret, so making difficult to share and advance science. And second, because sometimes scientific publications are so expensive that is an obstacle for low-income researchers, especially in developing countries. And finally, that makes difficult the access to some services, some medicines, vaccines that are crucial, for instance, for the right to health, or other rights, for instance, seeds for the right to, or peasants, for the rights of peasants. So because of these possible counterproductive effects of intellectual property, the conclusion is that this has normative implication for states. So the general normative implication is that states has to establish intellectual property regimes that foster its positive effects on innovation, but at the same time guarantee the right of persons to benefit from science and to enjoy the other economic, social, and cultural rights. And for that, the committee establishes some implication. For instance, to foster research, to finance and foster research that is crucial for the enjoyment of economic, social, and cultural rights. Second, to establish other incentives for innovation different to intellectual property. There is a thinking that without intellectual property, there is not innovation. That's not true. You can create other incentives. For instance, the so-called market entry rewards that delink remuneration of successful research from future sales. That can foster research without having all the inconvenience of intellectual property. And finally, the regulation of intellectual property has to be compatible with all economic, social, and cultural rights. For instance, not making difficult access to medicine, access to vaccine, especially for low-income countries and for the low-income persons in these countries. Having said that, the committee has applied that this has also stressed that this has also international implications. States has to use their voting powers in international organization to ensure that intellectual property regimes are compatible with human rights obligations. And that has to do, of course, with the right to health. In relation to the right to health, the main points that the committee has stressed is that intellectual property might sometimes be detrimental to the right to health because it makes inaccessible essential medicines in especially low-income countries. And with that, the committee has recommended that all states have to use the flexibilities within the intellectual property international regime such as compulsory licenses to guarantee access to medicines and vaccines and all other elements that are essential for the right to health. In that context, the committee supports the very well-known Doha Declaration on the TRIPS agreements of 2001. And second, the committee has stressed the importance of generic medicine for access to essential medicines, and that when states craft their internal legal intellectual property regime, they should avoid to grant disproportionately lengthy terms of patent protections that make difficult access to medicines or other elements essential for treating diseases.